Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
This presentation is obviously a reference to a famous courtroom scene that we're all familiar with if you've seen A Few Good Men. It's the scene where Tom Cruise is standing over Jack Nicholson and he's cross-examining him at trial. And Jack Nicholson is sort of the hardened colonel who's refusing to testify truthfully at the time. And Tom Cruise is saying, did you order the code red? And Jack Nicholson is saying, you want answers? He's sort of fighting back with Tom Cruise. And Tom Cruise is yelling at him. And actually so much so that in the middle of this line of questioning, Tom Cruise is held in contempt of court for the way that he's treating the witness. But he keeps pushing, sort of not tied to reality. And he pushes so much to where he finally says, I want the truth. And of course, then Jack Nicholson gives him the truth. But first, not before saying, you can't handle the truth, which is his reference to, hey, look, I'm about to drop a knowledge bomb on you that nobody wants to know because it's darker than you could ever imagine, which is essentially that this colonel is ordering all sorts of terrible things in order to keep the military safe, etc. So, but if only it were that easy. And for those of us who are trial lawyers, we know that when you do have a witness on the stand who is not willing to tell the truth, you can't just bludgeon them into oblivion until they finally cave and tell you the truth. It really doesn't work that way, particularly not when you're being held in contempt of court. And in reality, what we know is that it takes some mechanics and it takes some finesse to accomplish what you're trying to accomplish in pointing out that the witness has not been truthful on the stand that day. So, exposing the lying witness is one of the most important parts of trial. And it's a part where you have probably the most to gain as far as sort of scoring points in front of the jury. And it's also a part where you have sort of the most to lose if one of your witnesses is exposed as being a liar, which is why it's so critical that we have our skills down to go ahead and say, all right, I'm dealing with a witness who's not being truthful on the stand, so how should I approach this problem? And I think there's a couple of questions that you need to ask yourself, right? Just as a baseline as to why this matters. The first reason it matters is that your credibility is all that you have in the courtroom. And I mean that not only about your witnesses, but about you as the lawyer. You need to be perceived in the courtroom as the truth teller. You're not only in control of the courtroom, but you are actually presenting witnesses and presenting evidence that is of high quality and is truthful and that can be relied upon by the jurors. So let's start with the jurors. What are they asking themselves? First of all, the jurors are saying, is this witness telling me the truth, right? Does this witness really remember what happened? How credible is this witness? Do they have a reason to lie about the testimony that they're giving today? And in fact, it's incredible because across all states there are jury instructions, various jury instructions, that tell witnesses that this is their job. Their job is to weigh the credibility of witnesses. And so it's when we view the trial and the testimony that comes in through that lens, you have to put yourself in the juror's shoes and understand that they believe their job is to look at a witness and say, is this person lying to me? In fact, so I'll give you the example from California, since of course that's where we're out here, and we try most of these cases in California. And this is from the Judicial Council's Casey jury instructions, but I'll read it to you, and you can see the task that's being put on the shoulders of the jury. And it says, sometimes a witness may say something that is not consistent with something else the witness said. Sometimes different witnesses will give different versions of what happened. People often forget things or make mistakes in what they remember. Also, two people may see the same event, but remember it differently. You may consider these differences, but do not decide that testimony is untrue just because it differs from other testimony. However, if you decide that a witness did not tell the truth about something important, you may choose not to believe anything that the witness said. On the other hand, if you think the witness did not tell the truth about some things, but told the truth about others, you may accept the part that you think is true and ignore the rest. Do not make any decision simply because there were more witnesses on one side than on the other. If you believe it is true, the testimony of a single witness is enough to prove a fact. And that's from the Casey Jury Instruction 107 in California. So that's the juror's job, is to sit there and weigh the evidence as it comes in, weigh the testimony as it comes in. And so now let's ask a different question, and I'll give you a moment to think about it, because I present a lot on this question of credibility of the lawyer in the courtroom. And so I'll ask a different question, and the question is, what is your job when you're in court? You as the lawyer, you as the advocate, another term that we like to use, which maybe leads us down the wrong path sometimes when we're thinking about what is our job in the courtroom. So I'll pause for a minute, and I guess I'll say, expanding it further, what's your job when you're in trial? As the trial lawyer, what is your job? So here's a hint. It's not what the former owner of the Raiders football team, Al Davis, used to say, which is just win, baby. That is not your job as the lawyer in the courtroom, because of course you're an officer of the court. You're not just an advocate. And so I would turn you to Rule 3.3, which is that you owe a duty of candor towards the tribunal. That's in California, our Rule 3.3, the duty of candor, of course. And we also have Business and Professions Code, Section 6068, which says it is the duty of an attorney to do all of the following: to employ, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth, and never to seek to mislead the judge or any judicial officer by an artifice or false statement of fact or law. And that's our California rule, but various jurisdictions, as you know, have duty of candor and various statutes that govern what the lawyer should be doing. So it's sort of an existential thought for a trial lawyer, which is, am I here to win, or am I here to be a truth teller and to help the trier of fact, right? I want to help the jury, or the judge in some instances, reach the right decision. Not just the decision that's in my client's favor, the right decision, and for the right reason. And unfortunately, in the modern practice of law, a lot of lawyers go to law school and they have that idea sort of beaten out of their heads. And instead it's replaced with this idea that you win by all means, right? And that the ethical rules are almost like the rules of a football game, right? Where, well, yeah, I shouldn't step over there because then there's consequences. Instead, you shouldn't step over there because you shouldn't step over there, because it's your job is not just to avoid the consequences of getting caught. Your job is to tell the truth and to help the jury reach the right decision. So really, when I speak about credibility in the courtroom, which I said I do often, you need to totally rethink what your role is as a lawyer and totally reshape your purpose going into any hearing, any trial, and help the court reach the right decision. And so now let's turn to the circumstances in which you might encounter a witness who's not telling the truth. And specifically what we'll be discussing today, obviously we have these situations where, before a deposition, before trial, you might interview witnesses and they might lie to you then, but that's not really what we're talking about. We're talking today about the more formal settings in which you might encounter a witness who's lying. And first, we sort of draw the line between deposition and trial, and we'll talk about those differences. And the second is, you could have a friendly witness who doesn't tell you the truth, or you could have an adverse witness who doesn't tell you the truth. And those situations are very different as well. So let's start with percipient witnesses and expert witnesses in their depositions. There are really two schools of thought, and I fall squarely within one of them. So let's cover the two schools of thought for depositions. The first school of thought is that you're sitting in a deposition and you ask the question of the witness, Mr. Jones, did you ever have any conversations with Mr. Smith about this transaction? And you know you've got the goods on Mr. Jones. You know the answer to this question because you've got emails, you've got proof that these conversations took place. Maybe Mr. Smith told you, yeah, I spoke to him on these days, and here's my phone records showing that we had these calls. But you ask the question, and Mr. Smith sits back in his chair and he says, no, I never had any conversations with Mr. Smith about this. So the first school of thought, and some lawyers subscribe to this, is that you can hide the ball and you could say to yourself, this is great. I can wait till trial and then I'm going to ask him the same question, and there's no right answer, right? Because if he contradicts himself, then he contradicted himself. I can say you lied to me at the deposition, and if he still says it, then I can impeach him, and either way I can make him look like a liar in front of the jury. That sort of hide the ball strategy is a bad strategy. And there are a number of reasons that it's a bad strategy, both with percipient witnesses and expert witnesses. And so I'll now share with you the second school of thought and why it's preferable to that hide the ball strategy in a deposition when you have a lying witness. The second school of thought is that you essentially treat the deposition like trial in some ways, even though it's not and the rules are different, but that you get the truth out on the table to the greatest degree possible, including when you have an adverse witness who flat out lies about something and you know that you could torch them at trial, but you don't wait until trial to do it. There are some people where they've said don't impeach the witness during the deposition. Yeah, that's somewhat true sometimes. You're not necessarily impeaching them, but you want to know exactly what they have to say in that deposition format. And there are obviously a few different reasons for that. The first is that as great as a surprise as it might be to the other side, as great as it might be to surprise the other side with something at trial, you could be the one who gets surprised at trial, which you want to avoid, right? Maybe the response that you're expecting when you're saying, I'm going to save this for trial, comes in totally differently. And this witness has an explanation that you were not prepared for. And that's the purpose of the deposition, but you squandered it because you were hoping that you could trap the witness at trial. So get those facts into the record. Lock them down at deposition. Do not hide the ball, but put it all out on the table. Remember, your job is to be the truth teller, and you can't tell the truth unless you've done a thorough investigation into all of these facts during the discovery process, and you know which way the wind is blowing, right? I had a mentor, a trial lawyer who I tried cases with years ago, and my mentor used to say, you don't always know who's telling you the truth and who's not telling you the truth. And in fact, you don't always know exactly what the truth is because you've got folks on the other side saying the exact opposite. But your job as a trial lawyer is to try to find the truth and to steer towards it. It might not be a direct line. Sometimes you hear something and you're steering over here, you're steering over there, but try to find the truth and steer towards it. That is your job. So it starts with the deposition process and getting these facts out on the table. Let's say you've got an expert witness, and at the expert's deposition, you want to drill down on every last point, and you want to confront the witness with evidence contrary to his or her own opinions, just as you would at trial. So, what you're doing is you're saying, I need to know exactly what this expert will say in response to the contrary evidence. And with this expert in particular, you don't want any surprises. So what are you really looking for? You're looking to expose the weaknesses in the opposing party's case before trial. And there are a couple of reasons why you want to do that. One, so that you know what those weaknesses are. You're prepared to deal with them at trial and to attack them and exploit them at trial. Number two, you're educating the witness that this isn't going to fly. So whatever opinion you just gave me, you now see these weaknesses and it's not going to work. And number three, and relatedly, sort of along the same lines of thinking, what percentage, does anybody know what percentage of cases actually go to trial, right? And we can it varies by jurisdiction, but the answer uniformly is a very, very low percentage, maybe between 2 and 5% in your state, of cases actually go to trial. So why hide the ball and wait for something that has a 2 to 5% chance of happening? Instead, this is your chance to build settlement leverage. And so you go into those depositions, particularly the expert depositions, and you take them to the cleaners right there, and you can get them to back off of their opinions. And guess what you just did? You know, for that mediation that you have scheduled in a month, you just scored some major points, and you probably built some settlement value on your side, because now a truly credible expert may be calling up the opposing attorney and saying, I can't give these opinions that you've asked me to give because I don't want to be subject to a Daubert challenge, and my credibility is more important. The other thing that you might find, and it's very effective in expert depositions when you have an expert who sort of deviates from the truth or deviates from their area of expertise, which we'll discuss in a minute, is you'll find that confronting the expert with the particular professional standards that govern their profession is exceptionally effective. So I'll give you an example. There was an appraisal expert, real estate appraiser, who had given a number of opinions that were outside of this person's expertise, let's say, and in fact, if that person was sort of playing by the rules of the professional standards that govern real estate appraisers, then that person never would have given the opinions that he gave in this particular case. And so it's easy to see how you build on that, right? You start with the bad testimony. You point out the weaknesses you attack in the deposition, and then you say, Mr. Smith, isn't it true that you're governed by these professional standards? And isn't it true that those professional standards require you, not to deviate from X, Y, and Z rules, and to play by the book, and to maintain a certain level of professionalism in your candor in your opinions? And you'll find that experts very quickly retreat from their positions and are unwilling to stretch themselves in the way that the opposing counsel is asking them. Speaking of experts' qualifications, that's sort of a low-hanging fruit when it comes to attacking an expert in a deposition in a trial. I'll tell you a fun story that I have from a recent deposition that I took, which is that this expert had listed Harvard Business School on his resume. And it's sort of interesting because the dates didn't seem to match up with his other employment on his resume for having spent that time out there at Harvard Business School. And so I knew that I got him when I asked, and so it says here that you attended Harvard Business School. And he said yes, and look, and he reached into his wallet and he pulled out the student campus pass that allows you to gain access to the Harvard campus. And of course, anybody who had actually attended Harvard Business School wouldn't have done that. They would have just replied, yes, I attended Harvard Business School from these years, and I got my degree, and after that I did this. So he was already defending what he knew was a fake point, and it turned out when I dug a little bit deeper that in fact this expert had attended a one-weekend seminar at Harvard Business School, which is where he got his student pass because he was a valid one-weekend student for this seminar that anybody can pay for to get into. And so that was a fun moment. And of course, you can have a lot of you can get a lot of mileage out of that type of testimony from an expert, because then you can say, is there anything else on your resume that isn't quite true? And when you provided this resume in this case, did you intend for the jury to believe that you actually attended Harvard Business School? Is there anything else that you're asking the jury to believe that isn't true? And you'll find that folks will very quickly retreat from the positions that they've taken. Another one somewhat similar is I had an expert recently at trial claim that he was an adjunct professor for a university here in Southern California. And the truth is that this is a person who had given 1 or 2 lectures at this particular university as a guest lecturer, not an adjunct professor, and there is a difference, of course. And so we were able to expose that as being essentially puffery. He was inflating his own importance and his own expertise, which did not play well in front of the trier of fact. So, you have a number of different ways when we're talking about experts or others to find the areas where they're stretching the facts and exploit those areas in the deposition. And what I've found is that if you're successful in doing that, then by the time that you get to trial, that's really not going to be a very effective witness, because they've usually learned their lesson in the deposition that they probably shouldn't stretch the truth when you're in the room. And if you have one of those witnesses who still stretches the truth when they're in the room, when you're in the room, then of course we'll talk about how to impeach at trial. But a final story about an expert's qualifications while we're on the topic, and how to use them to rein an expert in and actually turn an expert in the deposition to start telling the truth and the truth that actually benefits your side. So I was called out to take an expert deposition of a very qualified, very prominent forensic accountant in Minneapolis. And I flew out there, and it was so cold that when I was walking from my hotel to the law offices where I was going to depose this expert, I pulled out my iPhone, and it was so cold outside in the negatives that my iPhone immediately shut off, because the phone just said, "I'm giving up on life. It's too cold out here." And so that's how cold it was. It was quite bad. So of course I was looking forward to getting this deposition done and catching the earliest flight back to Southern California. And I sit down with this expert, and he was a credible expert who was not willing to lie to benefit the other side. And he did not know at the start of his deposition that he had given all of these damages opinions in the case about lost profits based on a set of cooked books. And so what was great is, in addition to being a certified public accountant, a forensic accountant, and a credible one, he was actually a certified fraud examiner who was trained in spotting financial fraud. And so, in the middle of the deposition, after he's given his opinions, I go ahead and make sure, okay, are those all the opinions that you're going to give in this case, sort of lock him in. And then I turned to this issue of financial fraud. And I showed him an article that he had written about a decade earlier, and it was about the red flags of financial fraud. And he's sort of scratching his head at this point, because he is not there to testify about financial fraud, right? He's there to testify about lost profits. So I walked through the red flags and said, would you agree that this is a red flag of financial fraud? And would you agree that this would be a red flag of financial fraud? And he said, yes. And so walked through, and of course one of them is that there's more than one set of books. That's about, I don't need to be an accountant to know that that's probably a red flag. So what was really fun is then I got to show him the second set of books, because the other side had made the mistake of producing them through discovery. I say mistake, but of course they were obligated to, and we pushed until we found this stuff. And when he saw this second set of books, he was initially very confused. And he asked to go on a break, and I said, well, I've got questions pending about this, so I'd like you to answer the question, and then we can take a break. And so he answered the question essentially that, yes, this would change my opinion if these are the actual numbers. And then he went on a break, and when he came back from break, he gave me everything that I needed for the Daubert motion, because he essentially not only sort of withdrew his opinion, but he actually said, this is completely embarrassing, and I've never seen anything like this. And he had fully flipped, and so it was the sort of garbage in, garbage out that he was admitting to, which is that how can I stand by these opinions? So it was nice, because I was able to get all of that done in time to catch the last flight out from Minneapolis back to Orange County, California. So I didn't have to spend yet another day in the freezing cold. So that's some of the philosophy when you're in a deposition, some of the tips and tricks. Remember that you're not hiding the ball. Remember that you have a lot of tools at your disposal for exposing when folks are stretching the facts, and that you should use all of them in the deposition. Use them all. Don't save any for trial, because your case probably won't go to trial. And if it does, the risk that you will be surprised by what the witness says outweighs the benefit that you might gain by trying to surprise the witness at trial. And remember, in general, our philosophy is trials aren't about surprising the other side. Trials are about confronting the other side with the evidence that's been on the tables, right? We show all our cards and we go after them, and you're the truth teller. So this isn't a gimmick. It's not a game. You go after them. And you'll find that you can go into a trial much more confident with how everything's going to play out when you've already done that hard work in the deposition. You know what they're going to say, or you know if they have no excuse, if you're just going to catch them in a lie. So let's turn to that next concept, which is cross-examination, and how to show that a witness is not credible in the courtroom. And so the very first few that we'll talk about are not the one that you're thinking of, probably, right? When we talk to trial lawyers and we talk about confronting a lying witness on the stand, the first thing that we typically think of is that you're impeaching them with prior inconsistent statements, and you're typically doing that with testimony that they've given, in this case, in a deposition, although, of course, other inconsistent statements sometimes apply. But we're not going to start there. Let's just start with some of the other ideas that you can bring to the table for a witness who probably doesn't really know or shouldn't be saying what they're saying. Because again, what's your job? You're not just an advocate, but you're in that courtroom to be the truth teller. And you need the jury to see you as the person who's presenting only high-quality testimony, high-quality evidence. And that goes not just for your direct examinations for your own witnesses, but it actually goes for the questions that you ask of the other side's witnesses. You need to be asking questions that demonstrate you're not going to allow someone to lie to the jury and get away with it. So part of how we build that is we start with the witness and we say, is this person really even qualified to discuss this? And I'll give you an example from a trial that I handled. It's funny, there's a theme here because this trial was also out in a very cold area. So the theme is people calling me out into other parts of the country and then me being desperate to return to sunny Southern California. But this particular trial was in a part of the country that was blanketed with snow. It was the week of Thanksgiving. We were a couple weeks into trial. It was a really hard-fought battle, and many tens of millions of dollars on the line. And the other side was going to call up next a witness who was a very nice gentleman who had served, was a war veteran, had served in both the 50s and 60s, a good guy. And I was waiting to cross-examine him because what he was going to testify to based on his deposition was incorrect. And I was concerned, honestly, about the optics of the cross-examination because nobody wants to take this nice gentleman and go up one side and down the other in front of the jury. You won't be viewed favorably, even if you can expose that the person isn't quite telling the truth or testifying truthfully. The jury will tend to like that person more than you just because they're a likable person who is owed our respect and our thanks for their service. So I'm kind of sitting there going, I need to make sure that I approach this cross-examination very gently. And we get to the end of the day of trial. It's dark outside. Everyone's leaving, and he doesn't go on the stand yet, so he's first up to bat the next day. And I see him. He's a non-party witness. He has no lawyers. He's not represented. He's a third-party witness. And I see him standing outside, appears to be waiting for a ride to arrive or something. He's in the snow. And it's dark outside, and I'm going back to my hotel to prepare for the next day of trial. And I just turned to him and I said, Saul, do you need a ride back home? And he said, I would love a ride. I appreciate that. And so we walked over to my rental car, got in the rental car, and I said, where do you live? He said, I'm just over the bridge. So get on the bridge, and we're driving along. And he said, I'm just really, really nervous about tomorrow, unprompted. And I said, well, Saul, is it that because you've never testified in a trial before? He said, no, I don't care about that, but, they're asking me to say things that I really don't remember. And I said, well, I can assure you, Saul, that if you went to them and you confirmed what's expected of you, I trust that opposing counsel will tell you that all that's expected of you tomorrow is that you will tell the truth. and that you're not required to stretch anything or to say anything that you don't remember. And he said, well, yeah, but I feel bad because I was, they prepared me for my deposition and I sort of said all these things in the deposition. And I said, well, Saul, that means you get another chance tomorrow to tell the truth. So we show up the next day, and I was half expecting him to not be there because, of course, the right move by opposing counsel would have been to have that conversation, because I believe he probably reached out to them and said, hey, I've got to tell the truth, and I don't really remember what you're asking me to talk about. And he actually shared with me that he's got some pretty severe memory problems, and so it's in his older age he's suffering from memory loss. And I told him, I'm sorry you're dealing with that, and you're not required to say anything you don't remember. And so they put him on the stand anyways, and I think that was a huge mistake. And the reason that it was a huge mistake is that they asked him about this particular area of testimony where I was going to cross-examine him because it was important to the case. And he said, to be honest with you, I don't remember anything that was said in that conversation. And they said, well, and you could sort of see them scratching their heads, well, you talked about this in your deposition, right? So suddenly they're in this sort of improper impeachment land. It's sort of, well, are you trying to refresh his recollection? Or are you impeaching this person? And it suddenly turned into frustration from opposing counsel that he couldn't remember, but it was pretty clear that he was taking a stand and telling the truth. I honestly can't remember, and it doesn't matter what I said in my deposition. I couldn't remember it then, and I can't remember it now, and I know that that's probably not what you want me to say, but I'm trying to tell you the truth. I do have memory problems, and it's difficult for me, and so I'm trying to give you everything that I've got. And they sort of attacked him with his deposition, and now the jury is going to turn on you, right? Because now you're attacking this poor man who's telling the truth. The best part of it, of course, and where it really backfired, and we've got to go back to this idea that you're the truth teller, but you're also in control of the courtroom, and you're only presenting high-quality witnesses, high-quality evidence. We don't always have that luxury, I'll concede, as a trial lawyer. Sometimes the people who saw or heard what went down in this case are not the best witnesses, and you have to work with them to make sure that they can tell the truth and that it's the right thing and that they do remember and that, hey, you're not stretching anything here. And so sometimes it's difficult because you don't necessarily have a professional witness, an expert who's testified 60 times, whatever it may be. But here they pushed so hard that he said, I can't remember what I had for breakfast this morning. And he actually said that on the stand, and now all of the jurors' heads went from this poor witness to opposing counsel, and they were throwing darts with their eyes. And of course, what they were saying is, why would you put this poor man on the stand when he's telling us he can't remember what he had for breakfast this morning? And it was such a huge mistake for them to call him in the first place. And I can only imagine what might have happened if he hadn't been standing out there on that snowy night and I hadn't given him a ride and told him, all you have to do is tell the truth. You don't have to do anything but that. That's the only obligation when you're subject to a subpoena in court. So that's the first piece, right? I didn't have to cross-examine Saul on his memory, but the first piece is that you can bring a witness's memory into question, and you can call it into question. And you can do that, I would typically say, do that in a very gentle way, not in an accusatory way, but in a way that gives a witness a way out of having to lock themselves into the positions that opposing counsel is asking them to take. You're actually giving them, it's relief to them that they don't have to remember the things that they can't remember. And sure, if we can show them something that refreshes their recollection, that's great. And sometimes that works. That's one method of doing that if your own witness sort of suffers from this issue. But the very first line of showing that a witness might lack credibility in what they're saying is attacking memory as to these items. The other sort of low-hanging fruit is bias. And bias is sort of self-explanatory, right? You've got a witness on the stand and the witness doesn't have any memory problems. The witness remembers everything that happened perfectly, maybe a little too perfectly. The witness is sort of sounding like an advocate. And there's always the opportunity for you to throw in, right, and you're the defendant's brother, is that correct? And when you throw that in there, it can be very effective. for a jury to understand that, yes, you got to take everything that this witness says with a grain of salt. Remember, I just read the jury instructions, where what you're supposed to be doing as a juror is sort of weighing the credibility and thinking, does this person have any motivation to lie for one side or the other? So bias is sort of low-hanging fruit. I will say this about attacking bias of a witness. You don't just come right out of the gates and say, all right, state your name for the record. All right, and John, you're the witness's brother. That's not when you do it. What you do is when you're dealing with a fact that might be detrimental to your case, you're dealing with a fact that you're concerned the other side might be able to score some points on this testimony, you sort of work through that fact and you bring it up and you bring it to a point where there's a question as to the witness's credibility, right? So, an example is when this is the only witness who can testify as to this fact. So we sort of have to take this person's word for it. And you can sort of build this momentum to where you point out that, and your testimony here today is that you never had any conversations with Jim about that particular transaction. That's right. And Jim's dead now, so you know that you're the only person who can tell us whether that conversation ever occurred. You understand that? And you get a yes. And then that's when you drop it on him. And you're the defendant's brother, aren't you? And so you've sort of given it to the jury that, yeah, we got to trust this guy on this one point. And this person really does have a motivation to give biased testimony. That's when you use bias. Again, you don't want to take this bulldog approach and say, I'm going to come in there and just eviscerate this witness because they're biased and they're lying. You need to take a more gentle approach when you take this line of questioning down the bias road, because it plays just fine without you having to sort of tear the person's head off. It plays just fine to sort of suggest to the jury, well, it's something else for you to consider. You're not saying that this guy's a liar, but you are saying that you need to consider what motivation this person might have to not tell the truth, the whole truth, and nothing but the truth on the stand. The next way of attacking a witness's credibility on the stand is with prior convictions. That's Federal Rule of Evidence 609. Self-explanatory. We're not really going to get into that today. Other than that, somebody who writes the rules decided that certain convictions affect your credibility as a witness, and that if you have those convictions, that we can bring them up at trial, and the fact of those convictions means that the jurors are capable of determining whether that hurts your credibility, whether you're not telling the truth because you're the type of person who did this. And so again, the only point really to make with the prior convictions is you don't just throw them out there at the start of the testimony. Hi, Sarah, I understand that you're a felon, right? That's not your first question. Your question is, going down the line, building it to the important point, like I said, and pointing out, hey, and you're the only person who can really tell us that. And so, is it true that you were convicted of fraud, felony fraud in 2004? Right, you bring that up, and so in fact, that was in a courtroom, right, just down the street, or just down the hall from here. You could, you sort of build it that way, and that was for lying to your investors, and you served your time. However, whatever leeway the judge allows you in doing that, which is different from jurisdiction to jurisdiction. But the point is, you're building on this, and you're taking away, you're stealing some of the thunder from the other side, who's called this witness. And then finally, under Rule 608B, other acts of untruthfulness, which again we don't need to get into, but these are acts of untruthfulness that might not rise to the level of a conviction, but that the rule makers have decided that you can impeach with these acts of untruthfulness to demonstrate that this particular witness might not be telling the truth on the stand today. So all of that, all of those sort of low-hanging fruit, that's not that's not the main focus of what we're talking about when we're talking about a witness who lies on the stand. So now we're going to turn to what everyone first thinks of, which is impeachment by prior inconsistent statements, which of course is Federal Rule 613, or you also want to look at Rule 801 D1. So what's different right away about the idea of impeaching based on prior inconsistent statements and all those other methods of impeachment that I just demonstrated? Well, the number one thing that's different is that with all of those other methods, you tend to know that problem already exists with the witness before you confront them with it. So you have a lot of time to prepare for those credibility attacks. An example, the witness told me that he suffers from these memory problems. So I was ready to go if he lied that day and talk about the fact that he can't remember what he had for breakfast. Same with convictions. You've done your background checks. You know that this witness is a felon. You know that you can use the conviction if you need to, if they don't testify truthfully about everything. And the same goes with bias. You've done your background check. You know that this is the defendant's brother. You can prepare that testimony and you can have it down pat, ready to go for when you walk into trial. That is not the same as prior inconsistent statements. With prior inconsistent statements, you need to do this on the fly. So you need to be on your toes as a trial lawyer. And that's one of the things that distinguishes trial lawyers, which are a different type of animal, from other lawyers, even other litigators who don't go and try cases. Because you're not just sort of tied to your outline and what you expect the witness to say. You're ready for surprises. And you know exactly what to do with surprises. So let's talk about the outline for cross-examination and not being tied to it, but having a really good one. What does it mean to have a really good cross-examination outline? Well, one, it means that with the important questions, you know exactly how you need to ask that question, and I mean word for word, in order to tee up your impeachment with the deposition testimony. So specifically, you're going through the deposition transcript and you're saying, how did I ask the question? I want to make sure that it's not improper impeachment, right? It's fair, you've got the right context, and you're not straying from the truth of what was actually done when you're telling this court, hey, this is not the way that this person testified in their deposition. You better be darn sure about it. And so the first mistake that I see lawyers make in trial is they ask the question, did you ever visit so-and-so, in Denver in 2009? And the witness says, no, I didn't. And okay, I'm going to grab my transcript. And you said that you were in Denver in 2009. And he goes, yes, I was. And you go, wait a second. That's not the same question that was asked. You asked him in his deposition if he was in Denver in 2009. The question you asked at trial is, did you ever visit this person in Denver in 2009? And he says, no. That's perfectly consistent. That's improper impeachment. So you watch this happen, and a lot of times it's just because the lawyer didn't effectively prepare a cross-examination outline with the exact way that they wanted this question asked. So you need to look back at your deposition, and of course that all starts with the deposition and asking it the right way at the deposition so that you know how you can tee up your cross-examination at trial. And then what I would really recommend is that in your outline, you don't just have a reference to the page and line numbers from this person's deposition transcript. You actually have the written text from that transcript. What I like to do is I like to have it over sort of near a margin so that I can tie it to a question. And I do this only for the very important questions where impeachment's necessary, and we'll sort of get into that when you want to impeach. But where I know that I need the right answer, and I know that I need them to testify truthfully based on the admissions that I got from them in their deposition, what I do is I have my question written perfectly on the left side, and then on the right side I have the exact question and answer and page and line numbers from their deposition, so that you're coming into this cross-examination remarkably prepared. The second piece of preparing for cross-examination, and specifically the impeachment aspects of cross-examination, is that you want a binder that essentially this witness is going to view as the Bible. And what I mean is this: the witness is going to be terribly afraid for every time you reach for that binder, because they're going to know that you've got the goods there. And so here's what you do. The first time that you're going to impeach the witness, you reach over for that binder, even though you've already got exactly what you're going to impeach them on, and the pages and the lines sitting there in your cross-examination outline. But you take the moment, you build a little courtroom drama. You're also showing the witness, I'm sitting here at counsel's table with everything that's ever been done in this case. Do you see all this paper? Well, this paper, I know everything that happened. And by the way, I know when you're lying. So it's almost a sort of, hey, I can read your mind, buddy, and I'm going to keep you within the ropes here. And you reach over for that deposition transcript, which you've got in a binder. Best practices, by the way, in many jurisdictions, is to actually have another binder for your opposing counsel and have one for the court, so that it's really easy for you to turn and reference those. And we'll talk about what you're doing there. But that's the second step, is having that binder sitting there so that whenever you reach for it, that witness knows, oh no, I lied again, and Paul's coming for me. And that's really a very effective way of training a witness very early to sing like a canary, because that's what you really want. You don't want them hiding the ball. You don't even really want them to be caught in a lie. A lot of trial lawyers are really excited to catch the other side in a lie. You know what? I'd rather just have them answer yes to all of my cross-examination questions, and then I can sit down with all of the evidence that I need from that witness. But as we know, it doesn't always work that way. So I'll tell you the most important fundamental thing to remember when you're about to impeach a witness is to ask yourself this question. And hopefully you've already answered in your outline, but sometimes not. The question is this important enough to impeach this witness on this point? Is this point really a material fact for the trial? Let's say that the witness lies about what they had for breakfast that day because they can't remember, or they don't care, or let's say they just are a liar. Impeaching on issues that don't matter to your case is just a terrible way to waste the jury's time. And I'll tell you something from a lot of jury trials. When you waste the jury's time, they never forgive you. They will never forgive you. That is something, they are there being paid like $10 a day, like whatever it is, next to nothing. They don't want to be there. They want to be with their families. They want to be at work, actually making money. And so for them to sit there and do this, their civil duty, their service, and for you to call in witness after witness after witness, who has nothing really important to say, or who's lying, or who doesn't remember, the jury will turn on you very fast. And I've seen closing arguments that were effective where counsel began the closing argument by saying, I am so sorry. I'm so sorry that you had to sit through this case that was brought by the plaintiff when they showed you witness after witness who had nothing important to say, nothing about what actually went on, lied to you even. And I'm so sorry that we've just wasted the last 6 weeks with this exercise. And that's an interesting segue into saying, and by the way, you should award $0 in damages because we all just watched 6 weeks of nothing. And that's pretty effective closing. So start with this fundamental question, which is not just, I'm going to reel in every fish that I get on the line. It's you might have a bite on your line and you throw the fish back because it's not big enough. And that's the decision you have to make right up front is this really a point that I want to impeach on? So I'll tell you a fun story from a recent trial. There was a witness, an expert witness, who had testified in trial more than 50 times and who had given countless depositions. And this witness thought that he was pretty smart. And when I deposed him, I had been telling all of my experts, and I had been telling all of my own witnesses, that this person's name was pronounced Moyer, because based on the spelling, I thought his name was Moyer. So we were referring to his reports as the Moyer reports, And, well, let's see what Moyer says about this. And I mean, countless conversations, countless strategy meetings where we're talking about Moyer. But of course, I had only read his reports. I had never met him in person. So the deposition is the first opportunity to meet him in person. So I sit down, and of course, in a deposition, I say, "Good morning, Mr. Moyer. Would you please state and spell your name for the record?" And he responds, "It's pronounced Mayer." I said, "Oh." And I looked at the spelling again. I thought, well, that's an interesting pronunciation, but fair enough. And I sort of had to do a Control-Alt-Delete in my mind and reboot because I knew that I didn't want to make the mistake. And I think I even said to him, as someone with a 12-letter long last name, I'm sensitive to the fact that sometimes it's annoying when somebody mispronounces or misspells your last name. So I promise you I will try my hardest to call you Mr. Mayer and to stop calling you Mr. Moyer, and I apologize in advance if I get it wrong. And he said, fair enough. And we went along that whole day, and I believe, I haven't looked back at the transcript for this point of specificity, but I believe I got it right for the rest of the day. And as soon as I got out of that deposition, of course, I called all of my experts and I called everybody who was going to testify, and I said, hey, whenever you reference Mr. Moyer, it's not Mr. Moyer, it's Mr. Mayer, because he corrected me today. So I know this is kind of crazy and trials in only, 6 months or whatever it may be, but at trial, make sure you say Mr. Mayer. Okay. Fast forward 6 months to trial. We're halfway between trial. Everyone has been referring to him correctly. I was very pleased that everyone was able to successfully Control-Alt-Delete and reboot this part of their brain. I, even in my opening statement, was able to get it right. And remember, okay, so Mr. Mayer is going to talk about this, and you're going to hear from them, but we've got the competing experts who are going to say this. Okay. This witness is called to the stand by the other side as their key expert witness in the middle of trial. And of course, the first thing you do is that the bailiff sort of stops you right as you're approaching the witness stand and says, please raise your right hand, and has you sworn in. He's sworn in, he sits down, and they say, can you please state and spell your name for the record? And he says, Tom Moyer, and then he spells his name. And I looked at my opposing counsel, and my eyebrows were raised, and his eyebrows were raised. And I'm going, this is very strange, because that's exactly what I called him at his deposition, and he corrected me. And he told me that it's Mayer. And let me tell you something, I don't know about you, but on my worst day, I could have food poisoning and the flu and 0 hours of sleep. I'm not going to mispronounce my own last name. That is strange. And I have a complicated last name, but I don't think I've ever mispronounced it. It's sort of hardwired into who we are. We are able to pronounce our own names, and yet here he is. So I knew right away that this witness had come to the stand to lie, or to act, or to stretch the truth, because there was something fishy going on there. And what was so interesting about it is that even opposing counsel was visibly surprised during the direct examination, to the point where she sort of took a stutter step and said, oh, okay, Mr. Mayer. And she starts examining him. And then she says, Mr. Mayer, and you reviewed this document and you reviewed that document. Now, about 10 minutes in to this direct examination, I could see that he was a little nervous and he was just acting a little strange for a guy who's testified more than 50 times in a trial. And he said, I need to stop you, to opposing counsel. In the middle of direct, he says, I need to stop you. I've been mispronouncing my own name. That's what he said. And everyone in the courtroom's just kind of going, what? I mean, it was this collective sort of confusion going, yeah, what's going on with that? He said, it's actually pronounced Mayer, and it's not Moyer. I was just saying that. And so everyone's going, oh no. And I could see even the judge sort of scratching his head going, I don't understand why you came in here. And in your very first thing that you did, as easy as telling us your name, you didn't tell the truth. It was like you were an actor today. Very, very strange. So what was I thinking? Well, what I was thinking is this. Yeah, that's very weird. And sure, I could pull out the deposition transcript where he corrected me. Worth it? No. Not worth it to impeach. So if he had never corrected himself, as strange and frustrating as it would have been, I wouldn't have ever said, hey, isn't it true that I actually called you Mr. Moyer and you corrected me and all this, and so are you lying today? Right? You don't impeach on things like that. So it was great that he sort of impeached himself and said, I've been mispronouncing my own name, which was a great embarrassment. And of course, fast forward beyond that trial, in fact, that witness lacked credibility, and the credibility of all of the experts on that side was greatly called into question. And so, what do? You impeach on the other areas where that witness is lying. So that's first things first. The second thing that plays into it is sometimes it's a point that's not material, and it's so immaterial where it is possible that that adverse witness simply forgot the right answer. I mean, you could say, well, you never reviewed this before you showed up to give your opinion X, Y, and Z. And they might say, I think I did review that, to be honest with you. And you go, well, I'm going to impeach you. And it's okay. You could do a quick little impeachment, but it's often one of those things where you say it's not a big enough point to make a huge deal out of it. You can sort of approach it from the point of saying, hey, can I refresh your recollection? And you can use anything to refresh a witness's recollection. So it becomes a little bit less technical and a little bit more conversational and gentle, as I like to put it. Again, your job's not to be the bulldog who just eviscerates the other side. Your job is to be the truth teller. It's good to play by the rules and be stern and keep people within the lines, but not to tear people's heads off for essentially minor points. So remember, did they just forget? Is this material? How can I help them along to get them to tell the truth? Or are they really taking a stand, and are they really lying about a material fact? So you sometimes encounter that, and it's truly rare. But when you do encounter that, you need to know what to do. So now I'll share another trial story with you, which is a fun one, because of course, as trial lawyers, we just live on war stories, and these are the most fun for us. We could sit around all day hearing each other's war stories. So this is a fun one because this is a witness who was giving a major financial opinion in a multi-million-dollar case, and the witness was qualified on paper, and when I cross-examined him, one of the key sort of holes in his opinion was that it did not appropriately account for a $5 million payment that had been made. And when you sort of back out and go back to what we talked about before about the professional constraints on someone, the professional constraints on this witness, I believe, are what caused the following to occur. When I say, isn't it true that your opinions do not account for the $5 million payment that was made back in this year? The witness responds, what $5 million payment? And I say, is your testimony that you didn't know about the $5 million payment? He goes, that's correct. I go, oh, okay. And so if you'd known about a $5 million payment, you wouldn't have given this opinion today, would you? And he goes, well, it would be something I would need to consider, right? Because that's about all you're going to get out of an expert at that stage. And so then instead of impeaching him with his deposition transcript, where we talked about the $5 million payment, instead it was fun because I was able to go back to the very first email in his file, which was an email from my opposing counsel engaging this expert and saying, and by the way, we want to make you aware that there was this $5 million payment that took place. So not only was it one of the facts that this expert was aware of, it was the seminal fact, the very first fact during his engagement that opposing counsel, to their credit, made him aware of. Unfortunately, I think what had happened is that this particular expert had given opinions along the way that he knew he couldn't really defend at trial and still keep his credibility and stay within the bounds of those professional restraints. And so he abandoned it, pretended not to know about the $5 million payment, and it totally backfired. And in fact, that was in a bench trial, and the opinion that we got back stated that this expert, his opinions did not align with reality, that he refused to concede points that any credible expert would have conceded, and that the judge found that this expert was not credible, which was all correct. So Let's get to the mechanics of impeachment, because we've talked a lot about sort of the war stories, and getting to the mechanics is important for just knowing sort of the simple steps that you need to take to impeach the witness, which do vary by jurisdiction. And since this is sort of a national platform, we can talk about the various approaches, but it is actually fairly simple, right? You don't just stand up there with the deposition transcript and say, "You said," in response. There's a little bit of finesse required in doing that. So it's often referred to as the 3 C's. I don't care about the 3 C's, and I don't even like the 3 C's. And the reason is that acronyms are usually pretty good for remembering sequences or things or instructions that you need an acronym to remember. It's sort of a simple process to impeach a witness with a prior inconsistent statement using their deposition. You really, if you want to use the acronym, you can use it. So I'm going to walk through what the 3 C's are because people talk about them. And then I'll just talk about, what you actually need to do. So the first C is confirm. And this means that when you get a response from a witness that you know to be inconsistent with their prior statement, and you know it's material, so you know you want to impeach on it, you need to lock them in to that lie. And there are a number of different ways of doing that. And sometimes it just sort of happens organically because you're sort of surprised to hear the witness lie. And so you may be in front of the jury, and it's okay if it happens sort of organically, because then it's this sort of genuine response of, "Mr. Smith, did you just say that you were in fact at the meeting when this transaction was discussed?" And something like that. Did you just testify to that, or that sort of thing? You could just sort of confirm. Did I hear you correctly that your testimony today is that you were at that meeting? You're locking them in an unambiguous way, and you want to do it in a way where you're repeating the exact language from your outline, where you've got it teed up, because you will make sure, again, it's not you were in Denver in 2009. It's you were at that meeting with this person in Denver in 2009. Very specific. So you've confirmed, you've locked them in. That's sort of how I view it is, let's just get this really clear. And I'm going to I sort of view it as a lifeline for the witnesses. I'm going to give you one more chance, because maybe I didn't hear you right. I think I did, and I think you're here to lie today. But before I sort of embarrass you and score those points, I want to give you an out. So I'm going to let you know. What's interesting, different schools of thought, again, but sometimes you have trial lawyers who at this stage of the impeachment do not want the witness to know that they're about to be impeached. And so they'll actually, especially with witnesses who are maybe more experienced at testifying, they try to hide the ball, and they sort of do it in a squirrely way where, well, hey, so that's your testimony, right? And it's like, no, don't do it that way. Give them a real chance. You're a truth teller. Let them know that you're about to bring the train. And you want them to know, even at that point, I'm about to bring the train. So you can stand up in front of the train, or you can lie down and let the train through. And that's kind of, again, there are different schools of thought. This is my philosophy as a trial lawyer, as someone who needs to be a truth teller in the courtroom. You genuinely want them to know, I'm about to reach for this binder. And you know what happens when I reach for this binder. That's when I expose the lies that you're telling right now. So let's try to work with me here, my friend. And typically I sort of raise my eyebrows, and I make sure the jury's paying attention to the point, change the tone of my voice, and I lock it in. Mr. Smith, I want to make sure I heard you correctly. Did you just testify that, yes, you did in fact have a conversation with Mr. Jones about that transaction? And you do this while you're sort of reaching for that binder. So the next C is to credit. And this means that you build up the prior inconsistent statement. That is, once again, I think doesn't warrant the acronym of to credit. It doesn't necessarily even trigger that in my mind. It's just the mechanics of it, right? Is that you're going to walk through the prior statement so that you can build up the fact that they had every opportunity and reason to tell the truth at that time. The way that you do that with a deposition, since that's sort of what we're talking about today, is you take the deposition transcript and you say, as you're reaching for that binder, you say, Mr. Smith, you gave a deposition in this case, right? So you're crediting. Okay, they gave a deposition. And that deposition was on July 14th, 2008, right? Right. And you were under the same oath during that deposition that you took today before you took the witness stand. Isn't that right? That's right. It's an oath that says that you're going to tell the truth, the whole truth, and nothing but the truth. Isn't that right? Yes, that's right. And you had an opportunity to review the deposition transcript afterwards, right? Yes, that's right. And during that review, you had the opportunity to correct any errors that you saw. Isn't that right? That's right. And that's how you credit the prior inconsistent statement. What you're doing is, it's a bit of theater. It's also an important part of the mechanics of a proper impeachment. But you're essentially giving the jury the signal that I'm not just, when I reach for this binder, I'm not just reaching for anything. I'm reaching for testimony that this person gave under oath. And it was just 6 months ago that they said this under oath. So what I have here in this binder is important. It's not just something that was said willy-nilly. And then the final C of the 3 C's, if we're stuck in that acronym, is to confront the witness. And of course, what you're doing is you're confronting the witness. If they haven't already backed down from you reaching for that binder, which we'll talk about in a minute, you're confronting the witness with their prior inconsistent testimony. And so this varies jurisdiction by jurisdiction. In some jurisdictions, the preferred way of doing this is to reference the pages and lines to opposing counsel, make sure that they have the opportunity to review because they're allowed to review it if they want. Incidentally, in federal court, the witness himself or herself is not necessarily entitled to be sitting there reviewing the deposition testimony you're about to read, but the opposing counsel is. And to say, reading from lines from page 15, lines 12 to 18 of your deposition, you were asked the question, did you ever have a meeting with Mr. Smith in Denver in 2008? And your response was yes, right? You turn, and that's when you can easily choose your own adventure from there, right? Do you remember that? Were you lying then? Or are you lying now? You could do all however you want to take that. There are a million different ways to take that and sort of build off of that point to make the point to the jury that this person is not telling the truth or testified differently earlier. In some jurisdictions, and you want to make sure that you're very familiar with what your judge expects, actually, your particular judge expects. But some judges do expect a more formal approach, which is instead of just signaling, hey, everybody who needs to have one of the deposition binders has them. I'm referencing my page and my lines specifically, and I'm going to read them exactly as they are stated in the deposition, which is very important. Do not paraphrase. You get into a lot of trouble for improper impeachment if you paraphrase that, take it out of context. The witness is entitled to a proper reading of their testimony, as are the parties. So you sort of want to make sure that you play ball in the way that the judge expects when you're doing this, which is typically only important the first couple of times that you impeach, and then the judge will learn, and opposing counsel will learn, and even the witness will learn that when you do this, you're being fair, you're reading it correctly, you're playing by the rules. And what you want to do in some jurisdictions, even to start, is you can turn to the judge and you could say, Your Honor, once you've teed up, you've done the confirm and the credit steps, you're ready for confront, you can say, Your Honor, permission to, you could say permission to read lines, page 10, lines, 18 through 22 of this witness's deposition. And so that's a very formal approach. It's not required in many courtrooms, but and then the judge will say, yes, permission granted, counsel, and you can go ahead and you can torch that witness with their prior testimony and go from there. So, again, you score points in doing this, but use it sparingly. It is rare that you have to do this with the same witness more than a couple times. In my experience, if you do it right and you've got that binder sitting there, the witness learns very quickly that you are not to be messed with, and that you will pull out their testimony from their deposition and you will lock them in. And so they learn very quickly that, hey, I think I need to abandon my plans to lie today and just tell this guy the truth and sort of, fit within the narrative. And as I said, nothing could be better. It's not like I'm saying, oh, boo-hoo, I thought I was going to catch him lying more and he actually told the truth. No, it's a good thing that they're now here telling the truth, because if you've prepared properly, then your cross-examination questions are actually going to be answered yes, yes, yes. And you just sort of train the witness to give you a line of 40 yeses in a row, and then you're done with your cross-examination. In fact, I can tell you that the approach is so powerful once you have properly impeached a witness a couple of times, right? Sometimes even just one time, that many times in trial, all I have had to do is just sort of reach for the deposition transcript or suggest, you gave a deposition in this case, right? You start with you confirm what they say, and then you're telling me this? You gave a deposition in this case, right? And that's sometimes all I have to say, and I've had witnesses say in a response, when I say, you gave a deposition in this case, Mr. Jones, I've had Mr. Jones turn and say, yeah, and I probably told you something different in my deposition. Because they know I'm about to go reaching for that deposition and tell you what you told me in your deposition. And then I say, why do you say that? So you were under oath then, you're under oath now. You told me, you think you probably told me something different that day when you were under the same oath, and you can just have a field day with this in front of the jury and really point out that this person is essentially not credible. They've abandoned any attempts at even appearing credible, and now they're just sort of desperate to get off the stand and have you stop beating up on them because they don't know what to say and they don't even remember what they said before. And the reason they can't remember it is because they were lying before. They're lying then, they're lying now. These people make things up. So that's the key. So it's a very delicate dance. You want to suggest to the witness first, often before you really attack them, that they may not have properly heard your question. You want to give them an opportunity to remember the facts as they are. But once you know you've got a liar on the stand, you go through that process. You can go for the jugular. And again, train them to say yes, train them to lay down in front of the train, because they know they've watched you bring the train. The other thing that I will caution for attorneys who haven't tried a lot of cases is, do not be discouraged by sort of the awkwardness, or sometimes you might fumble on the transcript and not exactly know where you are if you're not all the way prepared. And sometimes opposing counsel might just jump right in front of you and say, objection, Your Honor, this is improper impeachment. And they may be saying essentially to you that, hey, what is stated in the deposition transcript is not exactly what this person asked here. And so this is an improper attempt to make this witness look like a liar when they're not a liar. Just don't be discouraged or sort of distracted from the cause. If you've prepared correctly, you've got this there. You can always request a sidebar with the judge. You could say, Your Honor, I've given opposing counsel a chance to review the testimony. I've given this. If you look at the real-time transcript, you'll see I'm asking the exact same question that this witness was asked in his deposition, and when I asked it to him today, he said yes. In his deposition, he said no. I'm entitled to confront the witness with that testimony. And the judge, assuming you're correct, the judge is going to allow you. The judge is going to say overruled, and you may proceed with reading the prior testimony. So let's turn to kind of the technical point under the rules, under Federal Rule of Evidence 801. When we turn to this technical point, it's a lot of people sort of ignore it, but in my view, it's somewhat important. Prior inconsistent statements are not hearsay. They are admissible to impeach, but not as substantive evidence. So what does that mean, maybe for some of you who aren't trying cases frequently and aren't necessarily keeping your finger on the pulse of the rules of evidence and sort of the hearsay rule, and why that matters so much. It really is critical in a trial setting. And it really ties to something that we talked about before, which was, is this a material point? Am I actually impeaching on something that matters, or am I just pointing out that this person's a liar and happened to lie about what they had for breakfast that day, which nobody cares about? You're wasting the jury's time again. So it's not hearsay, and the reason is it's not being offered for the truth of the matter asserted, and it can't be offered for the truth of the matter asserted when we're talking about just globally speaking, prior inconsistent statements. The exception, of course, is the key, which is unless those were made under oath. So what you're usually doing is you're usually working with a deposition transcript. That witness was under oath, and now under Rule 801, you can do a couple of cool things. You use this evidence to impeach, but you can also introduce it as evidence that's offered for the truth of the matter asserted, and because it was made under oath. So it's not always the case that you necessarily want the witness's prior testimony offered for the truth of the matter asserted, right? Sometimes your point is he was lying then and now. He never tells the truth. In fact, it's not what he said in his deposition, and it's not what he's saying today. It's actually neither of those things. Discredit all of this witness's testimony. And remember, under our jury instruction, it's if you decide that a witness did not tell the truth about something important, you may choose not to believe anything that witness said. So that's the point that you might be making there, is even in the deposition, I don't know if this guy was telling the truth. And that's why I'm pulling it out to show you this guy just talks out of both sides of his mouth. But there are other times where you got the admission that you needed in that person's deposition. You got that admission, and so it's Mrs. Brown. You said in your deposition X, Y, and Z, and the point that you're making is, I'm offering this for the truth of the matter asserted. You were under oath, and under Rule 801, assuming it was under oath at that time, you're permitted to offer it for that purpose. So it's a nuance in the rules of evidence, but it's a really important nuance actually, because you need to know why you're impeaching in the first place. Is it just to show that they're a liar? And I would submit to you that many times, if you can't say that you're offering it for the truth of the matter asserted, really, you probably should reconsider the impeachment to begin with. There are plenty of times where that's not true and where you should impeach anyways, even though you think what was said in the deposition is also bogus. But it's one of those lines that you have to divide, and you have to say, hey, I think it's important enough to bring it in, even if it's not for the truth of the matter asserted. So, put a bow on that. That's sort of our approach to the mechanics of impeachment. And we'll turn now to a totally different question, and I'm going to give you a minute to think about it, which is this. What if it's your own witness who lies on the stand? I'm going to give you a minute. What do you do? What are the various ethical considerations? So important for us to know these. So let me start by dividing up into two categories the same way we did with adverse witnesses, which is deposition versus trial. I've taken hundreds of depositions, and I spend a lot of time preparing witnesses for depositions. And the key, of course, is to get in front of anything like this. Something that I tell every single witness that I've ever prepared for a deposition is that the most important thing that I will tell you today is to tell the truth. The most important thing that I will ever tell you is that the only thing that is expected of you is that you tell the truth. The other side might try to trip you up, right? The other side might confront you with something and try to confuse you, or ask you a question in a confusing way. We're there to object when those things happen. But in general, the most important thing is that you're telling the truth. So you have to start there, because that's going to help you educate your witness, because the witness might be coming in thinking, hey, I want to do a good job at this deposition. Sometimes they're nervous. Sometimes they think they're needing to do your job and play the role of the advocate, which is not the case at all. What I want is for them to be very well prepared, which is why I spend days with witnesses sometimes, but to know that the expectation, the baseline expectation, the foundational expectation is that they will always tell the truth. So that doesn't mean that you'll never have a witness who says something that you know to be untrue in a deposition. And I can tell you that it's so much better, it's so much easier when it happens in a deposition versus in trial. So let's talk about the deposition format first, and then we can briefly talk about what happens at trial before we wrap. So you're sitting in your deposition, and the first hour goes by, and they're talking about the ground rules for the deposition. They're talking about the job that they had at McDonald's when they were, 18 years old, and they're giving their entire life's history, and you're going, wow, my opposing counsel really loves wasting my time. But here we are. Okay. And then suddenly, they jump into an area that matters for the case. And it's the area that you, as the lawyer, have truly studied. You are very, very familiar with these particular facts and what didn't happen, what did happen, the emails that have come through, etc. And the question is asked to your witness, and you go, I know this. This is great. I know all these answers, and my witness is very well prepared. So I could probably check out, but I guess this is pretty important, so I'm going to listen in, right? And the witness answers it, and then he goes back and forth, and then you get to another question, and you know the answer, and the witness says no when you know the answer is yes. It's a bit of a nightmare scenario because you especially if the witness is your client, right? That's difficult because now you have a very important witness who is lying under oath, and so the first thing you need to do is to figure out why this is happening. Is it the case that your witness actually has changed their mind or sees things differently, has information that you don't have? And so the reason that it's so much easier in a deposition versus trial, of course, is that you could take breaks during a deposition. And during that deposition break, you should go to your witness and say, hey, did you hear that question correctly? Because I heard you say no. And I could have sworn, based on everything that was discussed before, that the answer was yes. And in fact, I've got documents that show the answer is yes. So I'm a little concerned about what I heard in there. And sometimes right then and there, you'll have the witness say, oh God, is that what they were asking me? Oh my God, I must have misheard because I meant yes, that's correct, it's a no, or something like that, where there's just some ambiguity in there. And the good news is that you'll have the opportunity after opposing counsel ceases their line of questioning to jump in and say, yeah, I just wanted to clear something up from earlier today. I think that there was some confusion regarding a question that you were asked by opposing counsel. You were asked, X, and you responded Y, but my understanding is that you might not have. Is that the correct response? And that you give them an opportunity to sort of say, oh yeah, no, so I thought that I was being asked this, and thank you for the opportunity to clarify. The answer is not Y, the answer is actually Z, and let me explain the nuance there. And they can go in and say, so when I'm asked this question, I was confused. I thought that sort of what was being asked of me is this, but the answer to that question, if that's the question that I'm being asked, is actually Z. And so it allows them the opportunity to correct themselves. Now, as a final point, let's turn to trial, and let's just start with your ethical obligations, right? ABA Model Rule 3.3A3, a lawyer shall not knowingly offer evidence that the lawyer knows to be false. Okay, don't put a liar on the stand, my friends. It's not a good idea. In California, well, I guess actually let's move on. Let's stick with ABA. Move on to 3.4B, which is a lawyer shall not counsel or assist a witness to testify falsely. So remember, that's the baseline. Always, you've got to tell. You have to tell the truth. And if you move to California out here, just to give you an example, and it varies jurisdiction to jurisdiction, but we actually have a new rule, 3.3, which is candor towards the tribunal, which prohibits a lawyer from knowingly making a false statement of fact or law to a tribunal. But 3.3 actually goes further. It prohibits failure to correct a false statement of material fact or law that the lawyer previously made to the court or the tribunal. So your ethical obligations in this area make the trial situation so much more complicated because you don't have that same opportunity to just correct it without possibly hurting your case, hurting your client's case. And so be aware at all times when you're in trial that your witness, your witness is not more important than the truth. Your case is not more important than the truth. The most important thing is abiding by your duties as an officer of the court, your duties of candor. You still owe duties to your client. Sometimes clients or witnesses who lie might put those duties into conflict with each other. And you have to be terribly, terribly careful about how you tread, which is a whole different MCLE presentation, right? About approaching those particular ethical questions when it's your own witness who's lying on the stand. And in some jurisdictions, like in California, where they have a new rule, a lot of those complicated questions, right? Your witness, your client comes back to your office after a long day of testimony and says, thank God they didn't cross-examine me on this particular point because I was lying through my teeth about that. You are now in a very difficult position from an ethics perspective, the duties that you owe to your client. But you need to remember, and as I said at the start, to sort of put a bow on the presentation, you need to remember that your baseline duty is to be a truth teller in the court. And so at that point, I would recommend that you actually consult with an ethics expert. States have ethics hotlines that you can call and say, I'm dealing with the situation. You can do it anonymously. Many of you in law firms have ethics experts. We have them in our law firm. Folks who can be available to you to say, under the guidelines that apply to this situation, how am I to approach this? I'm afraid that the judge might not let me withdraw at this point, even though I may have grounds for withdrawal because we're in the middle of trial and it would be too prejudicial to my client. So there are so many different considerations that you have to sort of calculate at that point. And here's what I'll leave you with this you can't handle the truth presentation, is that if you get ahead of all of this and you make it very clear to your witnesses, to your clients, that the most important thing that we have is our credibility in the courtroom, and that nothing that we will ever do in this trial or in this deposition will be something where we're sacrificing our credibility. That we will maintain the truth and hold that as inviolate throughout this entire proceeding, no matter what. And if you've got difficult facts, then my friend, it's my job as your lawyer to find a legal strategy, right, to perform the research and do what we need to do to work with those facts. But we don't hide them, we can't bury them, and we certainly can't change them. The facts are the facts. So if your witnesses and your clients know that, and know that that's your whole philosophy of practicing law as a trial lawyer, and they know that going forward, you're going to have a lot of success. Not only because you probably won't encounter the terrible ethical quandaries that I've just discussed, but also because judges and juries will see from a mile away that you are someone who cares about the truth above all else, and that you're not selling them anything. You're just presenting the facts as they actually exist. And so with that, thank you for joining us today, and I hope you enjoyed the presentation.